Good afternoon, everyone. Thanks so much for joining us. Today, we have a special edition webinar where we are going to focus solely on employee termination. And as you all know, this is an aspect of the employment relationship that all employers unfortunately have to deal with from time to time, and handling terminations correctly is critical. That said, we're fortunate to have Adam Mastrolio back today to provide us with a refresher on this topic. I will now turn the program over to Adam. Adam?
Carrie, thank you so much, and thank you to everyone for being with us today. I can confidently speak for Carrie in that I'm sure she gets a ton of calls, just like I do, when an employer client of ours is considering terminating someone. And I've been getting more and more of those calls lately, and I thought it would be a good idea to work through some of the issues and considerations that employers have to think through and plan for when they are considering and then executing a termination. This presentation is intended to complement the current breakfast briefing series that Bond is putting on all across the state. I know our Syracuse breakfast briefing is tomorrow. So hopefully if you haven't signed up to attend one of those in person, I would encourage you to do that. Next slide, Kathy. Okay, so anytime an employer is considering terminating an employee, there are a number of things that the employer should walk through, like a checklist. The first thing, and we're going to talk a little bit more in detail about this, is the potential for a lawsuit or some kind of claim with the New York State Division of Human Rights or the Equal Employment Opportunity Commission that you might be able to reasonably anticipate. In dealing with my own clients, I can tell you there are times when I get a call and the client says, we would like to terminate this person, but there are several things that we are concerned about. So this is the first step in the checklist. Whether there is justification for the termination. We're going to talk about at-will employment in just a minute, but it is always a good idea to have a clear and explainable reason for why you're taking the employment action that you're taking, including a termination. And another consideration is whether a jury would agree that termination was justified. It's hard sometimes to take yourself out of the situation, but it's always a good idea to try to look objectively at the conduct that's being, what the employee is doing, what your policies are, and whether or not termination makes sense in when you consider those facts. Next slide. So we're going to walk through some of these issues. Now, the first one and one that I hear a lot is, well, this employee is at will, so we can do whatever we want, right? I mean, if you look at the definition of at will that's on the screen there, it is terminate an employment relationship terminable at the will of either party for a good reason, a bad reason, no reason at all, with or without notice. That is New York's rule. That is the default rule. But it doesn't mean you can do whatever you want, whenever you want. Next slide, Kathy. So some limitations on the at-will relationship. So number one, and this is the biggest category, and that is statutory exceptions. So you cannot terminate somebody for an illegal reason. There are various state and federal statutes that provide protections for employees against discrimination or retaliation on the basis of protected characteristics or protected activity. I'm not going to go into all the different protected characteristics with you today, but you're all familiar, I'm sure, with age, race, sex, gender, disability. Those are protected characteristics. And the law says, even though your employee is at will, you can't terminate somebody for an illegal reason or on the basis of one of those protected characteristics. The at-will relationship is also limited by employment contracts. These aren't all that common, but some employees have employment agreements in place. Those employment agreements almost certainly have limitations on how and when they can be terminated. So for example, you may see limitations in an employment agreement that require 30 days written notice for termination or some longer period, or they might say you can only terminate immediately if you have cause, and here's how we are defining cause. So just be aware that if you have an employee with an employment agreement, you would be limited in your ability to terminate them as well. Next slide. This is an at-will limitation that I think gets lost in the shuffle sometimes, and that is an implied contract. So you don't have a formal written agreement with your employee, but the employee may try to argue that there is some kind of implied contract based upon oral assurances by a supervisor, statements made by management, handbooks. We see this frequently, handbooks, policies, or practices, where an employee will try to say that those things create an employment contract. Now, whenever we draft handbooks, policies, etc., we make it very clear to say that while these are the employer's policies, they do not create contractual requirements or limitations on our ability to manage the employment relationship. Next slide. So you have limitations on the at-will relationship. Now, specific considerations. Do we have any documentation to support the termination? And Kathy, you can go ahead and click all the bullets in this slide. So has the employee received prior discipline? When we go into their employment file, I will always, my clients will tell you, one of the first questions I will ask when I get a call and it's, we'd like to terminate this person, I'll say, okay, what evidence do we have? Well, my first question will be why. And then my second question will be why, what evidence do we have to support your why? So what evidence do we have? Documented coaching, counseling, corrective action. Is there anything in the employment file that would provide a justification or evidence to support the basis for our termination decision? Keep going, Kathy, if you would. Thank you. Has an investigation been conducted if appropriate? So, was there a complaint made about a person or an employee? And if so, did we investigate that complaint? Keep going. If so, was there adequate documentation supporting the reason for termination? So, I mean, one of the things that you will always hear me and the other labor and employment attorneys here at Bond say is that documentation is very important, particularly when you are trying to justify a termination decision when it's being challenged later on. Are there prior performance evaluations that reflect concerns relating to the reason that you're going to be providing for the termination? This is very important, and I will say often employers, I don't want to say don't take reviews seriously, but many times we will see employment reviews, annual reviews, where the employee will get stellar marks. And then when we're asked about whether we think termination is a good idea, we'll say, okay, well, what did the reviews say? And the reviews will be overwhelmingly positive. And then the HR will typically say, well, but this is not what the manager is telling us. And so, this is always a struggle. Do we have the documentation to support our justification? Next slide, please. Keep going, Kevin. I put some interesting graphics in this one, so I apologize for that. Is the employee in a protected category? This is something that you always have to consider. Now, as I say here, every employee is in a protected category. It just the key in the analysis is whether or not there is a protected characteristic that is relevant to the issue at hand. So it's not just, is the person in a protected category that you have to think about. It's whether or not there is any evidence that the protected category is playing some kind of role in the termination decision. Because if it is, then we need to step back and really think through what we're doing. Is the employee receiving an accommodation? Another very important question, because the Americans with Disabilities Act and the New York State Human Rights Law both include protections against terminating or taking any adverse employment action against an employee due to a disability. So if someone's receiving an accommodation, we have to make sure that that accommodation isn't the reason, or their disability isn't the reason that we're taking the employment action. Is the employee on leave under the FMLA or New York State paid family leave, New York State sick leave? Is there some approved and protected leave that the employee is currently taking that may influence whether or not we have the ability to go forward with the termination and to avoid a potential claim? This is a big one. Has the employee recently engaged in protected conduct? We see this all the time. So an employee Employees sometimes can sense that something is coming. They can sense that the employment's not going great, things aren't working out, and some employees will be smart and file a complaint or bring a complaint to protect themselves. They'll say, well, my manager is harassing me because of my race, gender, sex, disability, etc. If that is the case, that's certainly a consideration in making the decision about whether to terminate. This is another big one. How have we treated similarly situated employees? Are we taking the same action against employees in similar situations? Because if we're not, if we're treating a similarly situated employee differently than we're treating this employee, then we may have a discrimination or a disparate treatment problem. And it's something we really want to think about before we move forward with the termination decision. Now, I will say that all of these considerations, all of these things that we're talking about, they're important to consider and think through. They don't dictate necessarily what you end up doing, but they're an important part of the process. Next slide, please. In addition to thinking about those questions that we just went through, you should also review company policies, company procedures. And you want to make sure that you are applying these policies and procedures in a consistent manner. The way that discrimination claims proceed legally is that the employee will say, we're talking about terminations today. So the employee would say, you terminated me because of my gender. And the employer will say, no, we didn't terminate you because of your gender. We terminated you because you were failing to meet your sales goals, for example. The employee in the legal analysis can say to a judge or to a fact finder, what the company is telling you is a pretext, it's false. And here's how I know. I know because they treat similarly situated people differently than what they're treating me, than how they're treating me. They are not applying company policies in a consistent manner, and that's evidence that they're not being truthful about the real reason why they terminated me. So that consistent application of company policy and procedure is very, very important. Particular attention, as I say here, should be paid to progressive discipline policies. I prefer progressive discipline policies that provide lots of wiggle room to the employer, that don't provide a rigid step-by-step process, because there are always going to be situations where steps should be skipped. So if you have a strict progressive discipline policy, you definitely want to check that and make sure you're following it. Internal dispute resolution policies, or termination policies requiring just cause. Now, we see that most often in the union context, because any termination of a union member has to be supported by just cause. But sometimes some employers will incorporate just cause protections into their handbooks or their policies. Next slide. Timing of the termination is important as well. And that becomes particularly important when it comes to potential retaliation. So if somebody files that internal complaint and a week later they're fired, you can see what the implication would be. The implication is the termination almost immediately followed the internal complaint or protected activity. And therefore, there's this inference that it was retaliatory. And that's something you have to be concerned about and think about when you're making decisions about when to terminate somebody. The note here is entirely correct. Employees who file complaints can still be disciplined. However, what you need to do is make sure that you have all those other things we talked about: documentation, clear justification for the action in writing, or a pattern of conduct that we can prove. That is what I always tell clients. Just because somebody is in a protected class or engages in protected conduct doesn't mean you can't discipline them. You just have to really make sure that your T's are crossed and your I's are dotted, and you have this clear justification that can be proved with evidence. Next slide, please. So is the termination legally defensible? To ensure termination decisions are defensible, you can and should follow a standardized procedure. Make sure that it's clear how you work through terminations in almost every case. That way, it's easy for you to say, we treat everybody the same. Here's how we do it all the time. Potentially, and I say potentially because this is not necessary, but potentially hold the organization to a just cause standard. As I mentioned just a moment ago, that just cause is typically an issue only in the union context, but it's helpful to go through the just cause analysis when you're thinking about terminating someone to make sure that you have everything in order. And as I've said a number of times already, treat all employees in a fair and consistent manner. Next slide, please. So when I say just cause, what is just cause? These are the 7 tests of just cause. They've been established over decades of jurisprudence, and they really lay out a very simple formula for working through if you're going to be terminating somebody. So do we have a reasonable rule or order in place? Number one. Have we communicated that rule or order to the employee? Did we investigate whether their conduct violated that rule and order that they knew about? Was our investigation fair? Did we give them an opportunity to defend themselves? Do we have proof or evidence that the employee violated the reasonable rule or order? Are we treating everybody the same? And is the discipline appropriate? Does the punishment meet the crime or is it on par with what the crime was? So if you can walk through these things when you're making a termination decision, it can help protect you against any potential claim following communication of the termination decision. Next slide. So we talked about the termination decision. So working your way up to the termination decision, you've made the termination decision. Now, what next? So what are the issues to address prior to your termination meeting, where you're going to sit down with your employee and you're going to communicate that they're going to be fired? So number one, do you have required documentation? Number two, do you have the last paycheck covered? Vacation and sick time, separation agreements if you want. And I'm going to walk through these on separate slides, so I'm going to go a little quicker here. Future references. How are you going to handle future references? Is the employee going to be owed bonuses or commissions? Are there stock options, retirement benefits, COBRA that you have to deal with? So these are things that you need to get in order prior to having that termination meeting after you've already made the decision to terminate. Next slide, please. So let's start with required documentation. New York has a labor law section that clearly says terminated employees must be provided with written notification that includes date of termination, the date of cancellation of any employee benefits, including medical insurance, and this written notification must be provided within 5 business days of termination. Typically, I advise clients to provide the termination notification, the written notification during the termination meeting. That's usually the simplest and easiest way to do it. But just so you know, you have to provide this written documentation under New York's labor law. Next slide. All right, the last paycheck has to be delivered on or before the next regularly scheduled payday. You can't condition receipt of the final paycheck upon agreement not to sue because the employee has already earned the wages and you have to pay the wages. You can almost never make additional deductions from a final paycheck. There are very, very limited exceptions in the New York State Department of Labor regulations and labor law, but they are limited. You should assume that you cannot make any unusual deductions from a final paycheck. If you have any questions about that, obviously reach out to the lawyer at Bond with whom you work regularly, and I'm sure they can answer those questions. But you want to make sure that the last paycheck is provided in a timely manner. I will say as a note to those of you on the call today with employees in different states, every state has a different rule regarding the last paycheck and that required written notification. Some states require that the last payment be made on the date of termination. So even if it's off schedule, some states say that when you fire somebody on a Monday, you got to give them their pay through that day on that day. And for example, in California, if you fail to do that, there are significant penalties. So it could be thousands of dollars in wages that you may end up owing if you're not following those final paycheck, final written notification requirements state by state. Next slide, please. Vacation and sick time, you have to make sure that you understand what the company policy is with respect to payouts of vacation and sick time at termination. This policy should be very clearly articulated in your handbook or in your collection of employment policies, however you handle that. But under New York law, if there is no written forfeit policy, no policy that says we don't pay out unused vacation at termination, the presumption is that all accrued and unused vacation and sick time has to be paid out. So that's something to think about. Maybe go back and check your policies, make sure that's in there. Because in New York, if it's not, if it's silent, you got to pay it. Next slide, please. Another consideration before going to that final termination meeting is whether or not you're going to offer some kind of separation or severance agreement. A severance agreement or release of claims is not offered in every case, nor do you have any legal obligation to do it. You should think about whether you want to do it in certain circumstances. So, for example, on the screen here, if you have a potential risk of a claim and you think that offering some kind of a severance benefit may entice the employee to sign a release, then that's a situation where you may want to use a separation agreement. You want to consider the reason for the employee's termination. You know, in reductions of force, sometimes employers will just offer a standard separation agreement that provides 2, 3, 4, whatever, how many weeks of pay to employees in exchange for signing a release. The biggest consideration in whether or not to offer a separation agreement is whether or not you want a release, because that's what the employer gets out of the agreement. An employee's release of any potential claims leading up to the signing of the separation agreement. That's the big prize, so to speak, that the employer wants, and that's why you offer the severance. Next slide, please. So some common clauses that we put in separation agreements, severance agreements, is a consideration clause. So that's the clause that says, here is what you are getting. We are offering you 4 weeks of pay as severance. They typically address references. My recommendation is always to just have a neutral reference policy. Don't provide anything more than position held, dates of employment. A release, as I said, this is the most important part of the separation agreement from the employer perspective. We want the release. Legally required disclosures. Here is where you get in trouble if you try to draft a separation agreement without the help of counsel, because there are certain disclosures that have to be included in separation agreements. Otherwise, they won't be valid. So, for example, the Federal Age Discrimination in Employment Act, the ADEA, requires very specific disclosures be made in any separation agreement for someone who's over 40. If those specific disclosures are not made, then the release as to any age claims is invalid, and the employee could then sue you for age discrimination, even though you have a signed release. Sometimes these agreements include non-disclosure, non-disparagement, confidentiality clauses, restrictive covenants, return of employee policies, employer property, I should say. All of these different clauses can be put into separation agreements, and you should work with your attorney on what makes sense for you. Next slide. So with respect to future references, my preference is always to limit the information shared to job title, dates of employment, final salary sometimes as well, but limit the information, do it in every case so that you can't, it just makes it much simpler and much easier if that's your policy. You don't get into providing references. And most employers will expect this. You know, it's not something where an employer would be put off by a former employer's refusal to provide specific detailed commentary on the former employee's performance. Next slide, please. Bonuses and commissions. Bonuses, typically not wages, can potentially be forfeited upon termination. Commissions are wages, can't be forfeited. So those are two things to keep in mind. Pay very close attention to whatever your bonus and compensation policies say, commission policies say, so that you are following them when you are issuing that final paycheck. Next slide. All right, so termination meeting, we've thought about why we're going to terminate. Do we have justification to terminate? We've thought about all the things that we do leading up to the termination meeting. So now let's talk about the termination meeting itself. So where do you hold it? On-site, off-site, privacy implications. If there is someone who is particularly volatile and you anticipate a combative conversation, you may want to have security present. You may want to make sure that you have resources available to you when you're delivering the news. There are certain times when termination by phone is appropriate. When to hold the meeting after the information is clearly documented and the facts are known. So my recommendation is always go through those first two steps that we talked about, analyzing the decision, thinking about all the things that we need to finalize the decision. It's up to you, morning or afternoon. Usually, well, I shouldn't generalize. That is very much an employer by employer decision. Who should be at the meeting? Typically, it's your direct supervisor, someone from HR. Always good to have a witness, whether it's one or the other, in order to validate what has been said. And you don't want the employee to come back and file a complaint and say, they didn't tell me why I was being terminated. If you have a witness there, they can corroborate that, yes, we did in fact tell you why, and here's what we told you. Next slide, please. All right, what to cover in the termination meeting? I am a proponent of providing a concise reason for the termination. There are certain instances where you don't have to do that, or you shouldn't do that. But for the most part, providing a basis for the decision, it helps alleviate any confusion moving forward. So you don't want the employee to leave and say, I have no idea why they just fired me. All of my reviews were great. I had great performance. I have no clue why my employer is doing what they're doing. It also, we talked about that legal analysis earlier, where the employer says, here's the reason why we did what we did. The employee is going to say, well, they didn't tell me why they were doing what they didn't tell me why I was terminated during the meeting. So anything they're coming up with after the fact, that's got to be false because they didn't tell me why at the time. So I generally advocate discussing the reason during the meeting, making it short, concise, clear. You don't need to get into a drawn out discussion, but providing a simple, to the point explanation for why is a good idea. You should address severance, any outstanding contractual obligations, briefly run through benefits. You're typically going to talk about COBRA here. Most employers have a benefits administrator that takes care of the COBRA requirement if you meet it. Explain the job reference policy. We don't provide references. We only provide name, dates of employment, title, potentially salary information. And then you're going to want to collect your company property. If this is an employee who works from home, you may want to have a conversation about when that property needs to be returned. But you get as much as you can during the meeting or immediately after the meeting. Next slide, please. Okay, there we go. So 12:30, Carrie, on the dot.
That's perfect. Thanks, Adam. We appreciate you providing everyone with this refresher. I know it was a lot in a short amount of time, but we appreciate it. Thank you, everyone, for tuning into the webinar today. We had Adam's contact information on, it was the first slide. Please feel free to contact him directly, or you can always contact myself with any questions. Gabe will be hosting the webinar next week on October 14th. Please join him if you are able to do so. Thanks so much. Have a great rest of your day.